We're here with Professor Katharina Pistor from Columbia University. Thank you very much for being here with us.
Thank you.
So, what is new economic thinking to you?
Well, new economic thinking is really to unpack some of the categories that we have used in the past to understand economic systems and financial systems. So it's bringing people from different walks of life around a table and rethinking issues.
You come from a legal background, and you are doing several projects with INET right now. Can you describe the one that is just finished?
Yeah, it's basically there are two projects leading into one another. The first one was really a project that tried to rebuild our conceptual framework for financial markets by deconstructing the old frameworks we had and build something new. And the outcome of that was what I call the legal theory of finance. It's an attempt to use the legal construction of our financial markets to really understand why they built up the way they were built up, why they crash sometimes, and to lead into a political economy of financial systems.
And where is that going now? I understand that there's a project to bring in this to more people on both sides of the Atlantic. So
correct. Yeah, correct. So we published our major findings last year, actually pretty much a year ago, in the Journal of Comparative Economics, the legal theory of finance and the case studies that led to the legal theory of finance. And we have now a network which I call the Global Law in Finance Network, because law is in finance, not outside it, together with Oxford University and Frankfurt University. Each of these sites, Frankfurt, Oxford, and Columbia University, is sponsoring doctoral students in law who are trying to really substantiate the legal theory of finance by showing how deeply legally structured our financial systems are.
do you see a change in perception in the way that people see your research with relation to financial markets and the law since the crisis?
I would say yes. I think there's a great perception, especially amongst the younger generation, to understand our world better, and I think they realize that what they've learned so far is insufficient. So another thing I did with INET was the YSI, the Young Scholars Initiative's winter school in Paris. And we offered 20 slots that INET was sponsoring. We got 390 applications. We had participants from Iceland to Turkey. So that, I think, gave me a lot of hope in terms of the next generation. In terms of my own generation or older ones, I think I'm getting some positive feedback. I'm going to a lot of conferences and workshops. I'm invited to present this kind of work, which suggests to me that at least people are willing to listen.
That's good. So when you see it from trying to visualize the legal theory behind finance and how it interacts with markets, what do you think about the recent attempts at sort of going back to regulation and trying to stabilize the situation and then try to build from there? What do you think about on both sides of the Atlantic?
Well, the way I look at finance now is to say that financial systems are legally structured. Everything from, every financial instrument is a contract. And they use property rights categories such as collateral to deal with them and make them scalable. But they do this in light of existing regulations as well. So you can think of the regulations as the scaffolding around which contracting takes place. So what is changing, or what has changed with the reforms, is that we have altered the scaffolding a little bit, but we also see the immediate response, which is sort of new forms of innovative contracting to get around them, right? If the financial system is essentially legally structured, then the most important comparative advantage that you're getting is to be ahead of your competitors in new financial innovation, which means new legal forms to get around existing regulations.
And do you think our legal forms are adaptive enough?
Yes. Well, they're enough adaptive. Sometimes they're too adaptive. I think the contracts are highly adaptive. The question is whether the regulation can keep up, and the answer to that is no. We're always behind. And I don't think we really have understood also how the contracts that are innovated now will interface with the stability of our financial system in the future.
So if we conceive of this as a race, what you're trying to do in your more theoretical research is to provide some background and try to see the original way that markets and the law are interconnected.
That's right. They're deeply interconnected. Absolutely, yeah. And the question is, when push comes to shove, in a situation where liquidity dries up, also a category that I think we can unpack in the law actually. But when liquidity dries up, we're seeing what I've called the law-finance paradox, right? So we need law to build global financial systems, but if we enforce all law as written ex ante, the system is on an autopilot for self-destruction. You don't even need herd effects. That will exacerbate it.
So you need some adaptability.
You need some, what I call safety valves. You have to suspend the full force of the law, and the critical question is where you do that and who benefits and who loses from these
interventions. So that brings me to the great topic of the eurozone crisis, something on which you've written for INET and Vox EU, among others. And I wanted to ask you, do you think that we've suspended, as you say, the full force of the law in Europe to sort of pass the worst of the eurozone crisis?
Well, we've done this highly selectively and probably not enough. What typically happens, and that brings me to a political economy of finance from my perspective, we typically suspend the full force of the law at the core or the apex of the system, less so on the periphery. We do it where the survival of the system is at stake. So then, of course, you can ask me, why then did we do it for Greece? And I think it was done for Greece whenever there was a real threat that the default of Greece might bring down the entire system. In that sense, at certain moments, Greece was relatively close to the core or the apex of the system. At others, it was pushed towards the periphery.
But you could argue that the private sector involvement was a way to try to do the restructuring of debt without causing a blow up in the system.
Well, yes, but of course that is also renegotiating the rules on the spot, right? That's sort of the suspending the full force of the law as we have written them ex ante. And the question is always who sits around the table and gets to renegotiate these rules and who's paying the bill for that, yes.
And so that leads me to a question specifically about outright monetary transactions,
right.
That untested tool by the European Central Bank that I personally would argue has already succeeded because it changed market perceptions at a crucial time. Mm-hmm. But there is a new ruling by the German Constitutional Court, which is sovereign in German legal matters and with the German basic law. What is your view on the recent ruling and their decision?
Yeah, it's an interesting ruling. I think it has been misinterpreted sometimes in the press. Some got it right, not everybody. It's a ruling where you can start thinking about whether actually the German Constitutional Court should have any say on this particular matter. It's interesting, right? We're talking about the European Central Bank as an independent European institution and the German Constitutional Court ruling on matters of policies by the ECB. The trick is that they basically had to give standing to Germans who claimed that it was an infringement on their democratic rights. Because at some point this might be costly for Germany, and in order to maintain the principle of democracy, we have to have full control over our budget. So whatever we have not approved to ex ante shall not be taken away from us ex post. And if OMTs might have that kind of effect, then this might be infringing German constitutional principles. That's the first trick that you had to think about. And then, of course, what did they say about the measure as such? It's interesting because obviously the Constitutional Court is also on a territory that it doesn't fully understand. It did issue an interesting ruling. It basically said, we think that the ECB is doing things for which it was not authorized. It is ultra vires, as we like to say in laws. It's beyond the powers that were given to it. Unless the European Court of Justice is willing to interpret what they can possibly do with OMT if they ever were to use it in a very, very narrow fashion. And here's what we're telling you you can do. It can't be unlimited, etc. Right? So the Constitutional Court says we are willing to say that you're still within power if now the European Court of Justice, which has the privilege to talk about European law, interprets the policy in a very narrow fashion. And so they deferred it now to the European Court of Justice to take a preliminary ruling on that particular matter.
Could this be a situation in which we're suspending the full force of the original contracts as they were designed in order to adapt to a new situation in which the European Central Bank has had to step in as the lender of last resort, and then OMT came at a time when markets were questioning a treaty reality, which is that the euro is quote-unquote irreversible. So could this be a way to give more saying to the European Court of Justice as a way to save face and stay within the framework of German law?
Well, I would say the announcement of the OMT, you could already say, is sort of borderline, certainly an extensive interpretation of existing treaty law, and you could say to some extent a suspension of it. That's certainly the position that the German Central Bank has taken. The European Court of Justice has the authority to interpret the treaty framework and actually has authority over the ECB in terms of whether it does things that are not granted by law. So that would still be very much within the framework. The real question is who gets gets to decide in the critical moment of a crisis how far we can use a framework that is always open-ended?
We like to say sometimes that the ECB is the most federal of European institutions, or one of the most federal of European institutions. So do you think in this case that the real burden of proof is on the side of the European Court of Justice, in the sense that as a federal European institution it has to answer to the ECJ rather than the German court, or the level of law, of European law, is not superior to German law?
Well, that's a really difficult issue. What is the relationship between German and European law? I would characterize the ECB, I'm not sure whether I would characterize it as the most federal, only if you say that the EU law is federal, which people don't like to say. But it is a unique institution because it is designed to be radically independent, I would call this. It's not only independent as most central banks are designed to be, but radically independent. If you look into its statute, it says it is not accountable either to any of the national member states, including the central banks, which are technically the members of the European Central Bank or the European system of central banks, and is neither accountable directly to any of the European institutions such as the Commission. So the ECJ can look at if they overstep, whether the ECB oversteps its boundaries, but doesn't really have full jurisdictions over its measures either. So we are on a really sort of interesting, gamble about sort of who has the ultimate power to decide the fate of the euro. Is it the ECB? Is it the member states? And what is the role of the ECJ?
But now that we take a step back and think about it, over the last half decade, Europe has gone through a huge crisis, and now things seem to have been improving. Greece is back to market. Spain is, the new darling of at least some investors, and they're calling it the new Germany. So, if you think about it from 5 years from now, do you think we will come to a point where we will need a new either a revision of the German basic law or a referendum in Germany to push toward a more federal Europe?
I'm not sure you need an amendment of the German basic law. The question is, whether we are on the right path towards greater centralization and integration. And there are different models out there. I think sort of the straitjacket model of greater fiscal control or control over the fisc of other member states is not one that I would advocate. I think we need a lot more coordination, and we need a lot of more risk sharing and cost sharing. That's the real issue. If you want to call this federalism, that's fine. But I think the key issue that Europe has to come to terms with is that if you want to have a common currency, you also have to figure out how to share the risk and the cost of that currency. And it's not only about control over fiscal spending.
Do you think that the process of European integration has challenged some conceptions about how we used to think of the nation state and things that we used to think as exclusive to the nation state? So now we have a common currency. As you say, there is no fiscal backstop to that. Some are trying to build it. Do you think that it is a positive path, and if so, it's one that we can do legally with the existing tools that we have, or do we have to innovate further?
I think we can do it within the legal tools that we have, largely if we have some flexibility in interpreting them. So laws are always relatively open-ended, and I think we can, I don't want to say play, but we can use that a little bit more. I hope we will get better on getting on a right path. I think right now we're not. I think the European Union and the eurozone very often gets it backwards, right? We really need sort of cost sharing. That means a cross-border resolution for banks and for sovereigns. And we're starting with the supervision before we think about resolution. I understand the political reasons, but I think that's a risky path to follow. So I don't think we're entirely on the right track, but I think the European project has been about redefining the nation state, whether they wanted to from the get-go or not, and that's part of what the project is all about. We sometimes talk about multi-level, doesn't really tell you so much, but the issue is that I think countries make concessions vis-a-vis an integration project. And I think that's a good thing. We still have to think about whether this is both legitimate, whether it's still democratic, and whether we have effective mechanisms of accountability. And that's, I think, a real long-term project to think about.
A follow-up on this point about resolution and supervision. Why do you think it's dangerous to start with supervision and not resolution? As it stands, the Commission has been debating with the EU Parliament and the Council how to build resolution and how to create a system that can withstand a crisis instead of too many steps to even manage. And then supervision is going ahead from the ECB.
Right.
Why do you think it's dangerous to?
Well, let's see what's going to happen this fall. The ECB has announced it's going to do a stress test before really taking over formally the supervision of the banks, of the largest banks in the eurozone. And it has announced, since we don't have a resolution mechanism yet and no European backstop, that the nation states better stand ready to bail out their banks or recapitalize them if they have to. So we might very well, by our own measures that we're now taking, trigger another jiggle of a financial crisis, or certainly uncertainty, and the cost will be borne by the nation states. And that within a currency union, I think, is not leading to integration.
No, we've done that before.
We've done that before. Well, we faked the stress test last time for exactly that reason, I would argue. So commentators always thought the Europeans were just a little softy. They had to be soft, because they didn't have a common resolution mechanism, a common backstop mechanism, which the US has. So you can do real stress tests if you have it, you can't if you don't.
In the Spanish bailout and in the debate surrounding the bailout of the Spanish banks, there was a question about whether there would be a European backstop. There's been back and forth on this. Do you think that there is a legal case within the existing treaties to have a European backstop for the banks?
No, not within existing law. I think we have to, that can be created, right? So in some of the mechanisms, we're still in the process of the reform. And so I think thinking about whether the European stability mechanism should have the authority to explicitly bail out national banks is a useful thing to think about.
And so that means that eventually we will need treaty change or not?
For that one, yes.
Okay.
Yeah.
Okay. So given your high level of involvement with INET, what other projects that you're working on do you think fit this idea of new economic thinking and its relationship with the law?
Yeah, let me mention two. One is the INET sponsored a winter school for the Young Scholars Initiative in Paris this past January, and we spent 4 full days with young scholars thinking about the legal theory of finance. And these were economists and lawyers, some political economists and historians in the mix. And it was a really exciting experience for me of a truly global university. The nice thing was it was like an incubator, 4 very intensive days. Students, I shouldn't say, these were postdocs, doctoral students, some assistant professors who really wanted to engage in these kind of debates. And I think this was just inspiring and a great way of also, having to defend and argue the theory and getting pushback from economists and lawyers alike.
So what do you think was the best question that you got, or the thing that made you think the most out of the INET experience in Paris?
What was the best question? Well, I mean, there were questions about sort of how can you differentiate your theory from others, which is always a very helpful question to ask. There were questions about whether my sort of the law finance paradox, whether this was truly a paradoxical situation, or whether sort of Bayesian updating can deal with the kind of problems that I identified as not resolvable and therefore perhaps leading to the law finance paradox. I think, yeah. So
how do you think that we can solve the paradox?
Well, if we could solve it, it wouldn't be a paradox.
Right,
so we cannot solve it. So what I'm basically saying, that's where the suspension of the full force of the law comes in. So we need the law to build the markets that we have. If we just stick to the law as we wrote it ex ante, and we have to deal with fundamental Knightian uncertainty, then we will have a crash. And so the only way to deal with that is to suspend the full force of the law. For me, the key is when and where do we do this? Do we always wait until pressure builds up to the very core of the system and then bail out the obvious targets? Or do we create safety valves further down in the system on its periphery?
If you could imagine a safety valve in one of the financial crises that we've seen, either in the United States with subprime, in the eurozone with sovereign debt, or even in the emerging markets this year, what do you think would have been a good example of that, so that we can better understand what you mean with safety valves?
Yeah, for example, if more and more homeowners can no longer service their debt, at some point you want to think about whether we need a restructuring of their mortgages at that level, or whether we just wait until they all have defaulted, have been evicted, then the next level of financial intermediaries gets under stress and it builds all the way up. So the question is, can we do some meaningful institutional design that you could actually ask for a restructuring of your contract under certain conditions?
So the idea would try to avoid getting to the apex of the core of the crisis and trying to deal with it earlier, and having the legal frameworks to apply that before.
Yeah. And there are legal frameworks that allow you to do this. The Germans, for example, have invented a very nice one during the period of hyperinflation of the 1920s, where they basically say if circumstances that were unforeseeable for both parties at the time when they entered into the contract have emerged, and neither party would have entered into this contract under those kind of circumstances, then they can go to court and ask for an adaptation of their contracts.
That's very interesting. So we go back to history and find a good solution.
Yes.
Well, Professor, thank you very much for your time. Thank you for joining us and being part of the INET world.
Thank you.